It's my pleasure to serve as today's moderator. Our panel today features three fantastic business leaders and intellectual property attorneys who work in the fields of beauty, IP law, and toys and games. Now, in today's discussion, we're going to hear firsthand about how they've commercialized their bright ideas and how they've used intellectual property to achieve success. So let's see. What I'd love to do is start with each one of our panelists, having them introduce themselves. And let's start with Andrea Evans. She's here. And I'd love for her to share the name of her company, what she does, how long she's been in business, and of course, what role does intellectual property play in her business?
Thank you, Marisa. I'm so excited to be here at InventionCon. And as you said, my name is Andrea Evans, and I'm the owner of the law firm of Andrea Hens Evans. And we are a full service intellectual property law firm where we provide patent, trademark, and copyright legal services to clients worldwide. And of course, intellectual property is extremely important from an attorney's perspective, but absolutely, I have my own intellectual property with my law firm. My slogan is invest in your idea. I also have a hands-on STEM program, Kidgineer, where we provide hands-on engineering programs for elementary age children. I have a mentoring program for lawyers, Boss Squire, where we provide mentoring services to lawyers that want to be entrepreneurs, and even a property management company. But today I'm going to be talking to you all more about intellectual property. But it's extremely important in my firm, as well as my other businesses, to own intellectual property so that we can use it as a sword to fight people off when they try to infringe on our brand, and then as a shield if we need to defend ourselves.
Thank you so much. I mean, it's fantastic, one, that you're wearing so many different hats, but that you're going to also be able to bring to this conversation such a unique perspective of someone who is not only a business owner, but also the advocate, the attorney in the space of trademark, patent, and copyright. So that's like that's the trifecta right there. So thank you so much. Next, we have Sherry Munson. And Sherry is an inventor, and she founded her own company, CLM Creations. Sherry, tell us a bit about yourself, what you do, how long you've been in business, and what role intellectual property plays with your company.
Thank you, Marisa. I am honored to have been chosen to be on this panel today. This is so exciting for me. Thank you very much. I am the founder and CEO for CLM Creations. And what I did is I invented what I'm calling the CLM volumizer. And it is basically a diffuser on a handle, a brush handle, a hair diffuser. So it kind of works like this with a blow dryer with your other hand, you can use it either with the attachment or without the attachment. Without the attachment, you can use it to detangle your hair as well. And then I also have my logo with the CLM Creations and the packaging. And I have actually 2 patents. I did the original patent 4 years ago, and it's a design patent. And what we did is after the design patent was done and approved, then we did a continuation to protect my product further from future infringement. So that helped a lot. And then I also have a trademark that's registered and one that I've applied for. I already have a registered trademark for my CLM Creations brand. And I also have applied for a trademark for my CLM Volumizer trademark, my company, my product name.
Wonderful. And what does CLM stand for?
So my full name is Sherry Lee Munson.
Of course. Okay. Well, thanks so much for sharing some details about what you're doing. I can't wait to delve in further with you because it sounds really fascinating, because this is not necessarily an easy process, but you were able to navigate it. So you're giving us, some of us who are novices, who are just starting this process, hope that we can likewise move through and obtain not only a trademark, but a patent. That's exceptional. Okay,
Thank
so
you.
next we have Matt Nuccio. He is a toy designer, inventor, and a manufacturing agent. Matt, why don't you tell us a little bit about what you're doing, your company, how long you've been in business, and the role that intellectual property plays in your day-to-day work?
Sure, sure. My name is Matt Nuccio. I'm a toy and game designer at a company called Design Edge, and we develop toys and games for toy companies all over the world, from the Mattels and Hasbro's and Spin Masters of the world to startups in the kitchen table. And trademark is essential in the toy business because oftentimes it can be worth more than a patent because products can become brands, and that trademark is carried across a brand. So, to give you an example, like a certain item, might be an actual invention, and then we'll say let's just use let's just say it's Cabbage Patch Kids for argument's sake. The Cabbage Patch Kid doll might have a patent on it, whether it be a design or utility, and that's for that. That's great for that job. But that Cabbage Patch Kid logo could be then extended to other additional things, from T-shirts to play sets to tea sets to you name it, baby cribs, and it's all about that trademark. And that's the trademark has value and it can be licensed out beyond just the product itself. So trademarks hugely important in the toy business.
Absolutely. They certainly are because, it's a saturated marketplace out here. And many times trademarks and branding, slogans and logos are like one of the easiest ways to distinguish yourself from others, from your competitors in that field. So thank you. Let's kind of get into this conversation a little bit because I want to sort of understand. I know that for every business that's created, it's usually created because there's an idea that someone has and there's a need that needs to be met. So Sherry, in your field, now you've launched CLM Creations. What was sort of the impetus behind that? Was there something, what led you to kind of launch this business?
Well, I don't know. Do you want to hear my initial journey as to how my product was thought up at this point? I don't know if this is the area that you want to put that in.
Yeah, because you are our inventor here, and I'd love to. Well, we all would love to kind of hear how this kind of journey started for you.
Okay, well, about 15 years ago, after I stopped giving myself, after I stopped getting perms, like a permanent wave for my hair, because my hair is very straight and very thin. So I always had a permanent wave. And I stopped doing that because I wanted to start coloring for gray. So I didn't want to damage my hair beyond whatever could happen if you use two different chemical processes. And I'm like, okay, let's try not to do that. So I finally discovered that a diffuser would work good at creating some natural texture in my hair, more body, it looked more like my perm used to look. And then I found out that I could not do the same thing on vacation. So on vacation, I had to figure out a way to do my hair. And it was just crazy because I could never figure it out. And finally, I thought to myself, well, what if I put a diffuser on a handle? That way, then it can be used with any blow dryer wherever I am located. And because my original, my diffuser at home, I have a big blow dryer with a big diffuser, and it just was not practical to travel with at all. It did not fit in the suitcase. So that's what I did. I put a diffuser on a handle, and then I started to look on the market for something similar because I've never been the type of person. I know, don't get upset, but I never really wanted to invent and create a company. I just never wanted to do it. It's the craziest thing. So I started working on my prototype over the next 10 years while I watched the marketplace. I had my hairstylist told me I should patent this item. My sister told me I should patent it. And all I kept saying was, I can't afford to do that. It's too expensive. And I just don't want to deal with that kind of stuff. And finally, after 10 years of developing my prototype and thinking about it, I started thinking about, when am I going to retire? I need to plan my retirement. And maybe this would be an opportunity for me to have some extra retirement income, because my current position, at the time, was becoming very stressful, and I was starting to have some health issues due to the stress. So I thought, I got to do something different. So that's when I decided to apply for the patent. So I talked to a local attorney and patent and trademark attorney that I was referred to. And we figured out that a design patent was the way to go. We did a search. We couldn't find anything. Although earlier, just to kind of give you an idea, I was always searching for like a couple of years before that to see if anybody else had created it, because I wanted to, just check my own to see if it was available, if it might be available, if I wanted to apply for a patent. So I found nothing, and neither did my attorney, and we decided to go with a design patent. And we took my prototype and did the drawings and applied for the patent, and then I got everything looked like it was going fine. I decided to start the company itself later in the year when I realized I could deduct all of my expenses from my business. And I thought, why am I not doing this? I better get my butt in gear. And I think I started my company like in the end of November. I'm like, okay.
I can appreciate that journey. I'm so proud of you for being able to decide, even though you thought it was somewhat uncomfortable and like how to do this, you actually stepped out there and figured, well, probably retained an expert. I think you said a lawyer to help you. Mm-hmm. So I'd love to we've got a lawyer right here. Andrea, I'd love to hear from you, because many times I'm sure you've heard, because you've had such a breadth of working in this industry and have worked with all types of clients. Many of them, I'm certainly certain, that come to you and are not quite sure what to do. How soon do you think a trademark owner should begin this federal trademark registration process?
And that is the $1 million question. So you have to ask it yesterday, how soon? Immediately. And there are a lot of misconceptions about trademarks. And I love how Matt said that, it's very important to have a trademark, because often a lot of people have ideas and then they research and they don't have something that's patentable and they do give up. But a lot of $1 million businesses don't have any patents. It's the brand. And so, like you said, there are a lot of people selling pencils, but the Louis Vuitton pencil may sell for $2,000 versus the one at the dollar store. And so it's critical that you protect your trademarks. And there are two types of applications you can file. One is intent to use and one is use. So when you create that name in the United States, it's not the first to use, it's not the first to file the application. It actually is the first to use. But before you launch and establish a brand and slap that name on all those widgets, you do want to do your own research first, just maybe using free tools like Google, and see if the name is out there. If you find that someone is using the name, the second part of that test is, are they using the name on things that are identical or related? So I can be Andrea for a law firm. You can be Andrea for lipstick, because the public won't think a law firm is selling lipstick. And then once you feel that you've done what we call your due diligence, your own research on your own, even going to uspto.gov and trying to do your own search, that's when it's time to consult an attorney to do a more formal search. And that attorney has been trained. In fact, I worked as a trademark examining attorney before launching my law firm. So a good trademark attorney can do a search that will have an analysis to be able to look at what exists and tell you what your options are. Now, when you file what's called an intent to use application, you can say, hey, I have not launched my lipstick business yet for Andrea, but I intend to. And you actually can start the process and file an intent to use application. So one of the biggest misconceptions is people say, hey, I have to earn a certain amount, or I have to sell a certain amount. And that's actually a myth. As soon as you know that the name is clear, you feel confident, you can file as an intent to use application. Now, for those watching that say, I never thought about even considering protecting my trademark, I've been in business 10 plus years. Well, you're actually using the trademark now. So you have a lipstick company, people are purchasing your products in and out of the state. So you can file a use application saying, I'm actually using it. Now, ultimately, though, when you file that intent to use application, the government won't register your trademark until you prove to them that you've used it. And that should make sense. You really have to sell the lipstick to someone. You have to actually have it on the packaging, the price tag or the label. And that should make sense because they won't issue a trademark for something that doesn't exist. So the timing needs to be immediately, because you end up paying less to secure the trademark. And like I said, use it to have in your pocket when you need to pull it out versus kind of flying under the radar. So having your business, selling your lipstick, and then finding out that someone else is using the name. So you need that trademark and need to start that process, because it is a process and something that can take as long as a year or a year and a half with the backlog that the USPTO has. And because you get to file extensions up to 36 months to extend the time to show use, it can even be up to 36 months if it takes you that long to make your sale.
That's right. That's right. Thank you for providing so much detail here, because it is a process, but it doesn't have to be a scary process. And it's certainly something that an inventor like Sherry can do. And you two who are watching us can do this process too. So you just want to, Andrea has told us you need to start now, though, to kind of begin to familiarize yourself with what to do next. Now, Matt, I heard you speak earlier about the importance of the federal trademarks in the toy and game industry. What makes that industry so uniquely suited to having federal trademark protection? I mean, is there something uniquely different about toys versus another type of product?
Well, I mean, it's no different than like Coca-Cola or Pepsi. I mean, these are national brands. These are things that everyone knows. So if you take, IP of, say, companies like Hasbro or Transformers or My Little Pony, these are things that everyone within the U.S. and outside the U.S. even know. So the brands are tremendous, are probably the biggest part of the portfolio. And these days they're being turned into movies. I mean, that's what everyone wants to see.
I see it, right. So it's sort of like the federal trademark registration is almost like a jump off point. So if you're going to be in business, perhaps you might consider having that federal registration, especially if you think about licensing your product. It'd be great to own that outright, your brand, or if you're working with the manufacturer, you want to make sure you have that brand before you start retaining other folks to make your product in bulk, et cetera, et cetera. So thank you for sharing that. Now, Sherry, your process, you did walk us through a bit of what your trademark journey was. Did you find it to be scary at the beginning, or did you feel like this is something I can handle?
Well, the patent was a little bit scary, but I think the trademark was a lot less scary because I'd already been kind of in business for a couple of years. I had decided early on that I wanted to try to license my product first rather than try to do it all myself. Once I decided to go forward and sell it, that's when I started looking at trademarks, because I wanted to put the name of my business behind on the back of the brush handle so that it was, it was marked, so to speak. And then I discovered that if I did trademark that name, then I might have a problem. For instance, I manufactured in South Korea, they might knock it off, and all of a sudden my name is no longer mine to use. That's what I learned, that people could steal my trademark from my name, from my company name from me, and actually tell me I couldn't use it myself because they trademarked it.
Okay, absolutely. That's actually accurate and true. Andrea, back to you. I'd love to kind of hear more about some of best practices for when you're advising your clients. So if they are, coming to you and wanting to obtain this federal trademark protection, what do you say to them to kind of make them understand how important and vital this is to their business?
Well, I think that it's very interesting because we all know that everyone has some type of intellectual property. So if you're an inventor watching, you need a patent. And there are commercials on television that say, hey, do you have this idea? You need a patent, you need a patent. But you have never seen a commercial that talks about a trademark. And so because they're so misunderstood, people assume, hey, this is my name. My name is Andrea. So if it's my name, no one can use my name. So you will introduce me today on this panel as Andrea, But if Andrea is trademarked for lipstick, then I can't put my name on lipstick. So your daughter may be named Chanel, but if you put Chanel on a purse or shoes or lipstick, the company's going to say, hey, this is a trademark that we're going to infringe. So one of the cases that I think went viral that kind of really explains it all is the Dr. Dre, the billionaire rapper, suing Dr. Dre, the medical doctor, for trademark infringement. We represented the medical doctor and won, but that case went viral because all the memes and all the discussion around it was, we don't understand, it's the doctor's name anyway. So the doctor will always be the doctor, but he can't, the rapper was saying, hey, we don't want you to use this name as a brand. So I think one of the biggest things that people should understand is that you can like a name, you can like a word, and people say, oh, my favorite word is abracadabra. That's fine. But in order for it to qualify for trademark protection, you have to intend to use it on products and services provided to others, or you're actually using it. And so I may trademark invest in your idea for my legal services and say, oh, you're so nice, Sherry, congratulations on everything you're doing. Let me give you a t-shirt. But that t-shirt having investing your idea on it would not actually qualify for a trademark because it's not a product that I'm providing to you in what we call interstate commerce. It's just a giveaway. So you may put your trademark on a banner and go to a hair show and talk about your brush, but we wouldn't call you and order up banners. And so I think, it's an interesting question that you asked her. Was it a scary process? People are not intimidated by trademarks, but they should understand that it is a legal document and it's still a legal process. And so because I represent individuals to Fortune 50 corporations, it's very interesting to see that most people try to file trademark applications on their own, either get the trademark and don't understand what they have, and some of the information may not be accurate, so it can be taken away, or worse, they are challenged for it and don't understand their options for the challenge, so they just abandon it and don't understand that they can fight back. And then last but not least, they don't police their trademark. And so once you get the registration, it's up to you to police it. The patent office isn't going to say, oh, another Andrea just filed an application for lipstick. That's up to you. And your own trademark can become very weak if you allow a lot of people to use it for different things. So I think that once you kind of get around those misconceptions and understand it's a legal document, even the patent office, you'll see on the website, says it's not required that you have an attorney to represent you for anything, patents, trademarks, or even copyrights, but it's recommended, and it's recommended for those reasons because you can end up spending more money to have an attorney fix your mistakes, or worse, the mistakes can't be fixed, and then now you're back at the end of the line starting over.
That's right. Absolutely. Absolutely. I guess we always sort of, coming from our office, we definitely have that wording on the website that we recommend a trademark attorney to assist, but there are lots of other places to go to get free resources. And I know, Andrea, you've had some experience working in a clinic setting as one of the options for folks who may be concerned about some of the legal costs. I know that Howard University School of Law has a U.S. Patent and Trademark Office trademark clinic, and I know that you provide some services there. So I encourage our attendees to look that up. It's on our website, a listing of all the schools of the places where if you're concerned about maybe not being able to retain a lawyer, you might be able to get a student attorney who's supervised by another attorney to assist. Okay, back to you, Sherry. What is sort of the one thing that you wish you had known? Now you're an expert now. You went through the process and you got your federal registration. In fact, you got one that's in the pipeline right now. So that would be your number 2. Is there one thing that you wish you had known about this federal trademark registration process before you started? Anything looking back on it?
Well, one thing that I thought was surprising when I first started working on my CLM volumizer trademark, we originally were trying to trademark the volumizer, which did not fly, not at all. I mean, my attorney even said, it's a common word, you can't use it. It's not going to happen. He said, try CLM volumizer. I think we can do that one. And so that's where that came from. So I kind of understood better that common words may have a problem in trademarks. You need to kind of specialize it a little bit more. And then the other thing I noticed, which is doesn't have anything to do with the trademark office itself, I don't think, but I discovered that companies were actually maybe looking at trademark applications, because as soon as a trademark was filed for, like for instance, mine was filed for on the 13th of January, I think it was, or something like that. And then 2 days later, I found out that the domain for CLM Volumizer had been taken. And so I went and did a search, I did a search to find out who owned it, when it was acquired, things like that. And yes, this company wanted to charge me $5,000 to buy my domain, because they just basically took the domain from right out from under me. Now, the good news is we weren't going to use CLM Volumizer for my domain, because I'm using CLM Creations, which I already have and own. But I wanted to get it just in case somebody was going to use it. And, I didn't want somebody else to have it and try to knock off my product and, scam somebody else. But for $5,000, no way.
Right. And you've actually hit on two important points, and I'm so glad you raised them. One is that it's sort of back to what Andrea was saying about, the trademark office, of course, wants to register every mark that is filed, but in fact, there are some reasons why your mark and your application might be refused. And one reason might be if the terms are descriptive, because every word is not going to make a good trademark, especially if it's not tied to goods and services. That's what Andrea was saying earlier. So thank you for kind of raising that, because this is sort of one of those reasons why you might be referred to an attorney, because they are going to know the litany of all of the different types of reasons why your application might be sort of derailed, procedural issues or substantive issues. And so knowing those things in advance can help you kind of sidestep them. But the other thing you raised was scams. So Andrea, you're working, with clients now, and your practice is pretty extensive. Have you noticed like an uptick in the number of third parties who are kind of scanning the register for contact information to contact business owners?
Yeah, absolutely. So I think we noticed during COVID that, and the trademark office noted that they had more applications than in the history of, any filings. And so it was good in the sense that people had a lot of time to themselves and had all these creative ideas and started trademarking. But one thing to point out is once you file that application, it's public. And so there are businesses that immediately go by the domain name. They immediately go by the social media handle. And it's important to note that for someone to buy the domain name and own the social media handle is not actual trademark infringement, because having the domain name and social media handle don't function as a brand. It's more of your address. So when I say go to evansiplaw.com, that's the address. So meet me at 55 Main Street. When you get there, branded on the store is Macy's, so that's the brand you would trademark. So we often tell our clients during our consultations, okay, the name looks good, go ahead and Google it. If you don't see anything, go buy your domain names and buy variations, plural, singular, .com, .net. And even if you don't plan to use it, you can forward it or just have it to control your brand, because ultimately what happens is if it is used, it can divert business away, and now you're spending more money to sue them for possible infringement if they do start selling similar products. And then lastly, there's a spectrum of trademarks from strong to weak. So it's important for people to note a stronger trademark is a word you make up, and that makes sense. No one should have that name. You created it, Google, something that's not in the dictionary. And then we go down the spectrum to arbitrary words, which is a word that means something, but nothing related to the product. Apple for computers. So you can trademark Apple for computers, but not for a fruit, because it would be generic. And then sometimes we have suggestive terms that make you think about it. So Tide for laundry, Tide means something, but it kind of makes you think, oh, okay, water, but it's not immediately descriptive. And descriptive trademarks can be registered, but they're weaker. So it's describing something, but people would likely use it in a sentence. So the whole point is sometimes you may have a strong word plus a weak or generic word to make your mark, but the government will ask that you don't own the exclusive rights to those generic or descriptive words. So I think that you have to be careful because there are a lot of scams, not only that come by email, but some even in the mail. And because I own trademarks, we get them every day. And every day, I can count the number of clients that no matter how many times we tell them, hey, everything's going to come from our office because the USPTO will contact us. They still ask about that. And so one tip is that if you are filing pro se with no attorney, the emails that come from the USPTO have the @uspto.gov ending, and so that's really important because we're the U.S. Patent and Trademark Office is where you file the applications, but there are companies that may reverse it, or patent office. I don't want to even say their names because then it will confuse people, but it is something to look out for. And that's also one of the benefits of working with an attorney, that they can decipher what's spam and scam and what's not.
Exactly. And another important thing to note is that the office actually does have like a docketing system, this thing called TSDR, where you can also, anytime you get correspondence from a third party or you got a question, you can actually just look into this TSDR, which is on our webpage, and it allows you to see every document that was issued by the U.S. Patent and Trademark Office. You can compare and determine whether something is actually legitimate. So yes, there are a lot of scams, as there are in any industry, but there are ways to kind of to safeguard yourself. And we've got on our website, we've got maybe 4 or 5 different pages up to help you navigate that process and to help you figure out what to do if this happens to you. But let's jump in and talk about manufacturing, because you can't talk about going to market without having a company that can actually get you there. And so, Matt, we want to bring you into this conversation because you're in the business of working with clients and taking their initial idea into products, and then into manufacturing those products on a large scale. Do you have any advice for inventors who are just starting out? Is there something that they need to do to prepare before they come talk to you about their product?
Actually, I'm pretty early in the development stage, and I recommend that they speak to me first, actually, because oftentimes I'll get inventors who go to a patent attorney and they, spend a year developing a patent on an idea that they've never built a prototype for, or if they built a prototype for it, it was just proof of concept, but there was no concept of manufacturing behind it. So sometimes we'll get an idea and it may work well, but it's not designed in a way that it can be mass produced at a very good price. So what happens then? Well, they have to go back to the patent attorney and have the patent either adjusted or amended or whatever it needs to take. And that just costs more money. So you're best off going to someone who understands the full process and can actually engineer and design the product to be marketable, but under NDA, and then bring in your patent attorney or work in conjunction with the patent attorney and make sure it's developed. Because you don't want just a bunch of good patent drawings that can't be manufactured. It's nice to have a patent certificate on your wall. It's another thing than cashing checks.
That's true. And in addition to that, I'd love to get your thoughts on adding that trademark to this conversation, because I imagine if you're manufacturing, and so many folks are manufacturing outside of the United States, how important is it to kind of vet that brand name in that market? Because do you recommend, as you're kind of selecting your brand name, to sort of think about what that translation might be or how it's going to be used over there?
Yeah, I mean, I think the classic example is the Chevy Nova, right? Which sounded great here in the U.S., but meant no go in the Spanish
Right.
countries. Yes, it is important to get a sense of in the key markets what your product name is going to translate to, and or get trademarks in those countries for alternatives. Something that might make particular sense, but at the same time, branding that logo to keep the essence of all the other logos. So you're aesthetically branding your trademark, the look and the feel of it, but the words may be different.
Right, right, right. Now, you know, Andre, I was going to bring you into this because when you're talking about working, getting your U.S. Federal trademark, but then you're having your products manufactured outside of the United States, you start running into some sticky issues when you do that. Do you have any kind of tips, some pros and cons, or things to think about as you're maybe moving and thinking about working with China or maybe the Philippines? What do you think?
Yes, so great question and great points have already been made. And one of the benefits of having a U.S. federal trademark is that you actually can register it with customs. And so we've all been to New York or seen fake purses in different places, and having that trademark registered with customs will help to try to avoid having fraudulent products here in the United States. But the second point I wanted to make is there's no such thing as an international trademark. And so often inventors and entrepreneurs will secure a trademark in the US, and so you can enforce it in the US. So if someone in China is using your trademark and they only use it in China and never come to the US or sell the products in US, you can't do anything about that because your rights are only in the US. So as a strategy, there is a way that you can file applications in other countries. And the way it works is, as U.S. attorneys, we work with law firms all around the world and act as a liaison as your counsel here in the U.S. to give you advice. And so part of that consultation is mapping out a strategy to say, okay, I am going to sell it here. I am, what can I do to protect it in this country? And then you want to be careful because some of the countries have different laws, and that's why we would need to consult with an attorney where you may have to have a physical address there. You may have had to have a sale before you actually file and apply for that trademark. So you want to make sure you're not doing things too fast or doing things too slow, so that's why it's going to be critical to understand your options. But that is one of the benefits, that if you say, well, I am going to get it made in China, but my main goal is to use it only in the US, that could be one strategy versus planning out and mapping out what you plan to do in other countries. But you have the option to do that when you're ready. But you have to be careful because there's a way that you can link the applications together for priority to get an earlier date. And there's a window of time. And if you miss that time, then you're at the end of the line like everyone else.
Right, right. That Madrid protocol and that process. Okay, absolutely. And there's some more information at uspto.gov to talk about the Madrid protocol and how to even initiate that process, either with a federal trademark application or a federal trademark registration. All right. So Sherry, let's get you in here because you have actually done this process. You have worked through the pitfalls and the success of manufacturing. Tell us, where are you manufacturing your product? Is it in the United States or outside? And then how did you even start?
So I chose to manufacture in South Korea. And so my understanding when I started asking people, well, where else do I need to get a trademark? And they suggested you always should get a trademark in the US plus the country you're manufacturing in. So yes, I did the trademark application in South Korea before I ran out of time, as Andrea said. I know exactly what she was talking about because my attorney kept reminding me we need to do this before it gets too late. And it did. It was very helpful because I got both trademarks, the first trademark in like 13 months. And then the second trademark, I think, took just a little over a year for the South Korea trademark. So I did have it trademarked in both countries. And so, yeah, South Korea is where I'm manufacturing. I chose that just because personally, I didn't want to manufacture in China. I don't know. As a personal choice, I said, let's try to find somewhere that's, maybe a little bit more friendly country government wise. And so that's why I chose South Korea.
That's good to bear in mind because, when I know lots of folks decide to, they select their country sometime based on just the perceived ease of just obtaining the product quickly, not always thinking about what happens if something goes wrong. Do you know anybody over there? Do you have a presence over there? How easy is it to work with the government? These are all questions that might come to mind. So thank you for that. I'm looking at the time and I've really enjoyed this conversation. I want to kind of sneak in one more question here. And this is really just a general kind of business advice kind of question. Um, what all of you have had unique journeys in the creation of your own businesses and or working with clients who are trying to create their own. Is there some advice that you might want to share to someone who's just starting out? It could be from the business perspective or from a legal perspective of what they should expect, maybe something that they should look out for. And I guess I can start with you, Matt.
Something that they should look out for. Just making sure if you're inventing a product, your concept shouldn't end at how do you make the product. You should be figuring out straight through the distribution channels. A lot of people build product, they park it in the garage and they figure it's field of dreams. So, they made it, they will come. It doesn't happen that way. So during that process, figure out where you're going to sell it, how you're going to sell it, if your margins are correct, and if you can actually profit from it before you go investing in inventory.
I love that. Spoken for like a business person. Thank you very much. Okay, what do you think, Andrea? What do you have to add to this?
Well, my advice would be to seek the help of an attorney sooner than later to ensure you understand your options. And the reason why is because you can jeopardize your rights if you wait too long. It may be too late to file a patent application to secure your application filing date, or with a trademark, you may think that, oh, you're too small, so you don't need it. But no idea is too small, and everyone has to just start, right? And it starts with something. So no one necessarily starts out large. So you want to be clear that you patent inventions, trademark their names, copyright written works. So you're going to patent the television, trademark Sony, the brand name, and then copyright the scripts of the television show. And understand that everyone has some type of intellectual property. Take advantage of resources like this and all of the great information that the patent office has. But don't think that you're too small, because I always say it's better to have everything protected so that when Oprah knocks on your door and says, I'm ready, Sherry, to invest in your brushes, you have all the intellectual property to be able to sell, license, assign, or will down the line.
Absolutely.
And of course, invest in your idea. That's my federal trademark.
Okay, I love that. Okay, now Sherry, you're going to close us out. I'd love to kind of hear, do you have any advice that you'd like to share with another inventor?
Yes. Being a new inventor, I really didn't know where to go. So I started with the attorney, but then I started getting involved with social media, and somewhere along the way, they found out I was inventing something, and they gave me in the feed an inventor a Facebook group to join. And it was like the answer to my prayers, because I learned so much information. I got involved with the United Inventors Association that way. Marcy McKenna, who runs the Women's Inventors Club Network Facebook group, she found me. I would not be where I am today without that kind of resource, the people that I met through all of these different groups. And then I've also just recently joined the regional group through the United Inventors Association here in Minneapolis. So that was another one that I probably should have done sooner than later, but with COVID, that's when I started my process, which was in COVID time, about 2020, when I started to actually start moving towards manufacturing. I didn't know what was available. So I basically learned from everybody on Facebook that, and United Inventors Association and places like that. But well, yes, very, very important.
Thank you. I didn't mean to cut you off, but thank you so much for sharing those resources, because that's exactly what I was hoping you were going to say. So before we go, seeing that we're all about branding, where can we find you, Matt? How do we follow you? What are your handles?
Well, most people follow me on LinkedIn.
Uh-oh, I'm losing you.
My name should be spelled along the thing, so it's Matt Michio. But you can also make can you hear me now?
Okay, try one
Hello?
more time. Go ahead.
Sure. So you can go to designedge.net or you can find me on LinkedIn.
DesignEdge.net or LinkedIn. Thank you. And Andrea, what about you?
I am actually on all social media platforms at Evans IP Law. So you can find me everywhere on social media at Evans IP Law. And you can also text Evans IP Law to 33777 and subscribe to my firm's newsletter.
Wonderful. Thank you. And Sherry, how do we find you and follow you?
So my website is clmcreations.com. And I am available on, I think, pretty much all the social media platforms as at CLM Creations LLC.
Fantastic.
Because
Well,
CLM Creations wasn't available.
I understand. Happens every day. Okay. Well, thank you, Sherry Munson, Andrea Evans, and Matt Nuccio for joining us, and all of our attendees. Thank you for sharing your afternoon with us. My name is Marisa Terrell, and I hope you have a fantastic day. Thanks so much.
Thank you, Marisa.